All right, everyone, I'm back. Let's do some criming. All right. So this chapter is on the concept of crime. We're going to, with a specific focus on criminal defense and how defense attorneys want to challenge, you know, uh, criminal charges in court and what some of their strategies are. And there are two basic ones we'll talk about. So, but before we get to the defense attorneys, we're going to briefly go back to our friend the seven ingredients of the crime. And so this is not a legal definition of crime. It's just the factors we typically see that come together in the definition of a crime. Okay, so going back to the first week of class, for something to be a crime, it has to meet these seven conditions. You recall we talked about act, legality, harm, causation, mens rea, guilty mind, concurrence, and punishment. Okay, now briefly, we're going to go back through these again. What is the act requirement? Well, basically that some consciously committed an act, right? From mind to action, mind to body to action. That's how we defined it in week one. The crime requires that someone consciously committed the act. So, for example, if there were cases where people sleepwalked and argued, well, I was sleepwalking, so therefore no crime was committed. I wouldn't try that in court. You can be cited for failure to act, but as we pointed out, it's pretty rare, and there are actually only two states that have Good Samaritan laws. All right? The second is the legality requirement. Well, basically, there has to be a law that says the act that was committed was in fact illegal. But more importantly, the law must be clear as to what constitutes a crime. So now, of course, one strategy a defense lawyer may take is to argue that the law is unclear on what it constitutes a crime of the action that's being brought before a judge. But normally this is really done more on appeal than in a procedural trial, which is actually what we're going to talk about here. So let's just assume that in the cases we're talking about in this class, that both the act and legality requirements have been met. Third, we have to have the harm requirement. It's not a crime unless there's some sort of harm caused. Let me tell you, essentially, give you an example of that. Or from the conflict perspective, there's no crime unless it is believed harmful by those with power to create laws. So let's just take marijuana use. So why was marijuana use made criminalized or made illegal? Well, it's because people believe that using drugs caused harm. Now, marijuana is legal, and about half the population of the United States lives in a state where marijuana use is now legal. And because in those states they've decided, well, in fact, using marijuana doesn't meet the harm requirement anymore. It doesn't really hurt anybody. And if people want to smoke it, I wouldn't suggest they do it, but if they want to, let them do it. So that's about half the state's position right now on the use of marijuana. So the harm requirement. Moving forward, causation. Basically there has to be a direct result between the action or behavior of the criminal and the outcome. And next, mens rea, the idea of a guilty mind. And we'll keep this one in mind because this is one that will get challenged. So we hear things, if you've probably heard, and in fact, one of the cases we talked about at the beginning of the semester, the Supreme Court cases, that ignorance of the law is no excuse. Well, it can be if the law itself is considered to be too punitive. But in most cases, in order for a crime to be committed, you need to have what's called mens rea, or the idea of a guilty mind, or the idea that the person knew what they were doing was wrong. We'll keep that in mind as we move through to our full discussion about the different types of ways attorneys may challenge a court case. All right. Next, the concurrence requirement. In other words, guilty mind must be accompanied by causation. The punishment requirement, where unless there's a specified punishment in a criminal act, the act may be inconsiderate, but not criminal. Okay? So there has to be a legal punishment. All right. Typically, we also want to make sure that the punishment in some ways fits the crime. Now, Just as a quick review, the Penal Code recognizes 3 degrees of severity. Felony, which is the most severe, subjects punishments of at least a year or more in prison, or all the way up to capital punishment. Misdemeanors, which are less severe crimes, subject to a maximum of 1 year in jail, typically with heavy fines, probation, community service, etc. And then violations are minor offenses and normally subject only to fines. I've had violations, caught speeding, parking tickets, stuff like that. Now, defense can claim 2 strategies, and this is really sort of the point of the chapter. So what the defense wants to do is, when defending a client, you want to try to prove that one of the 7 elements of a crime do not exist. And defense strategies can take one of 2 or both, really, approaches. One is claiming that the crime is excused. The other is claiming that the act was justified. Okay? So those are the 2 options. So let's start with defense excuses. What are some excuses the defense can use? All right, so probably the most common people think about is the insanity defense, which is attacks mens rea, which, well, they didn't have a guilty mind because they were insane. They weren't capable of forming the intent to engage in the actions that they did and knowing that it was the difference between right or wrong. Similar to that is the guilty but mentally ill, is that you admit guilt to the crime, but in the sense that you still say you couldn't have formed mens rea. All the other elements of the crime may be met, causation, legality, etc. But if the mens rea is not there, then it is also it's an excuse. The intoxication defense, incapacitated by a drug or a drink. I was intoxicated to the point where I couldn't form mens rea, or I couldn't, form essentially the act. It has been used. Weirdly enough, it has been used successfully, but again, it's not where you want to be standing legally as you're facing a judge and jury. Infancy, too young to be aware of harm, and so infancy gets into, clearly the law is very clear that infancy sort of ends at age 7 in the United States. But then infancy gets into, when we're dealing with juveniles, you can imagine this becomes, 11-year-old that shoots somebody. Are we going to try them for murder as an adult? Are they old enough to understand essentially what they did? These are the kinds of questions that get raised. Mistake of fact. There was no intent to harm. I accidentally took the wrong property, etc. So the one excuse is, again, that what I did was a complete mistake, and it wasn't something that I was expecting. And then lastly, that's ignorance of the law, unaware that the actions that you took in this case were in fact illegal, and that the lawyer is seeking to get the charges dismissed based on these grounds. All right. Now, move on to, within this, we could talk about the test of insanity. So the insanity defense, although it's really not used that often and rarely used successfully, it is something that most people think they know quite a bit about. So we're going to kind of go through the history of the insanity defense in the United States, and we're going to skip over this slide and go to this one, the McNaughton rule. So essentially, here's what we have. For the longest time in the United States, the McNaughton rule was the precedent for insanity defense. And it basically meant, it goes all the way back to the 1850s. So what McNaughton does, and this is important to write down and understand and to underline on your notes, the rule McNaughton created a presumption of sanity. In other words, all defendants were assumed to be sane unless the defense proved insanity. Okay, so the burden of proof was on the defense lawyers and not on the prosecution or the jury to prove that the person on trial was insane. And each state has different standards for what passes as is considered insane behavior. Sorry. So what does McNaughton teach us? Sorry, I'm going to back up here. And it's not going to let me back up. All right. In the United States, what did I do back here? Nope. All right. So McNaughton is basically here, McNaughton is the rule of law where and it's still the rule of law in about half the states in the United States today. And McNaughton basically means that the defense has to prove that their client is insane. Well, that hasn't always been the case, it wasn't the case in all states. So in 1954, there was a case in which the product test, or otherwise known as the Durham rule, was instituted. And what this case did is, for a brief time, it forced the prosecution to prove sanity, as opposed to, so if a client comes in and proves, well, testifies that I was insane, I was temporarily insane when I committed this crime, the burden was then switched under this case to the prosecution to basically show that the accused was in fact sane. So that shifts the burden. McNaughton, the burden was on the defense. Under the Durham rule, the 1954 decision, the burden now goes to the prosecution. Now, in 1972, in a case, the United States versus Bronner, the ruling then, basically, the court punts the ball, and instead of putting the onus on the defense or on the prosecution, they turn it over to the jury. So the ruling under Bronner was substantial capacity either to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law. That was essentially the statute that had to be met, the standard. And who decided whether or not the court met the standard under Bronner? The jury decided, not the judge, not the prosecutor, not the defense attorney, but the jury had to make a decision as to whether or not substantial capacity was present to appreciate the criminality of the conduct. Okay? Now, 1984, the Comprehensive Crime Control Act, the federal insanity defense at the federal level, it basically changed us back to McNaughton, actually. So in 1984, the Comprehensive Crime Control Act, the federal insanity defense, requires the defendant to prove by clear and convincing evidence that they didn't know right from wrong. Okay, so essentially what happens in 1984 for all federal crimes, McNaughton is now the standard. Today in Texas, under Texas law, the insanity defense requires a defendant to provide evidence of a mental disease or defect that rendered them incapable of knowing that their conduct was wrong. So essentially, Texas has never really veered too far from McNaughton, and we're back to McNaughton now. Again, let's keep in mind, we start off with McNaughton, the burden is on the defense attorneys. Okay, the Durham test shifted the burden to prosecution in certain states that accepted the Durham decision. In 1972, the Bronner decision essentially put the onus on the jury to decide who was sane and who was not insane. And now we've kind of rolled back to McNaughton. And in the 1980s, we sort of shifted back, and now about half states in the United States, including Texas, are McNaughton states. All right. Let's talk about a little bit more about this insanity defense. So some of the major questions here, you'll see that, there's much debate about it, but how is insanity best determined? Is the client still guilty of the act? I mean, this is legal precedent is brought up in these kinds of arguments. The insanity trials are often sensational, and because they get lots of media attention. Typically, less than 1% of felony cases involve some sort of insanity defense. So while it sounds, great and wild and crazy, the insanity defense is rarely used, and very rarely used successfully. All right, the second type of defense, justification. So duress, someone forces you to commit a crime, is a justification. And we will talk, let's talk about this terrible case of a guy named Brian Wells. And there's a Netflix show called Evil Genius about this that you should probably watch. It's pretty good. He was murdered by a woman named Marjorie Armstrong and a couple of her partners. It's a case where Mr. Wells was a simple-minded pizza delivery guy in his 40s. And they were trying to get money to hire a hitman to kill Marjorie Armstrong's father, who had a lot of money, and she was his only surviving heir. And if he was dead, she would inherit his money. And so what they did was they built a bomb, and it was a ring. They attached around Mr. Wells's neck, and they sent him into a bank in Pennsylvania, and they told him to hand the note to the teller. They handed the note to the teller saying, "I want X number of dollars." He didn't get X number of dollars. And then after the crime, after he robbed the bank, they were going to pick him up in a car and take him somewhere and get the money and then take the bomb off of him so he would be safe. Well, what happens is the police show up. And when the police show up, they see this thing around his neck, and he tells them it's a bomb. Now, I didn't put it on him, somebody else did. So the police hold him at gunpoint, and he's sitting on the ground out in front of the bank. The police are surrounding him. They're trying to figure out exactly what's going on. And of course, there was a timer on the bomb, and the police standoff took a while. The bomb goes off and kills the guy, Mr. Wells. So had Mr. Wells not been mortally injured in that assault, if the police had been able to get the bomb off of his neck, his attorneys would have attacked his criminality based on the duress justification. He had been forced to commit a crime. He had that bomb attached to his neck. Again, he was a pizza delivery guy. They ordered a pizza. He goes to the house. They quickly grab him, put this thing around his neck, and then force him to go rob this bank. And the bomb goes off, blows his head. It's this horrible situation. But they would have attacked his case based on the duress justification that he had been forced by these people, Marjorie Armstrong and her companions, to rob this bank. Okay? And there's a link to the YouTube video that has a short story about it. You can cut and paste, I guess maybe not from a video, but you can, I will send you the link in an email that you can watch, or you could watch the Netflix show Evil Genius. So other defenses: necessity, believes that the crime was necessary for survival. Public duty, crime occurred as part of your state-sanctioned activities. We talked about this with justifiable homicide 2 chapters ago. And self-defense, you were defending oneself against the crime or harm. Now, so essentially, in order for self-defense to be a justifiable defense, you have to be able to show that the person must believe that force is necessary. They must believe that they are in immediate danger, that they must believe the harm threatened to them must be unlawful, and that the force they use in response must be reasonable. Okay? So one of the controversies is, by whose standard do we judge reasonable fear, reasonable force, etc.? And of course, one of the most famous cases is the Trayvon Martin trial, where Zimmerman claimed that he felt fear for his life from this young man that he had was trying to apprehend in Florida, and felt justified in the use of lethal force. Now, Mr. Zimmerman was not a police officer. He was kind of a self-appointed security guard in the apartment complex where he lived. And of course, the jury agreed with him. And in Florida's stand your ground law, they felt like he was justified in the lethal violence that he used, and it was, of course, very controversial and still is to this day. All right, so we're at our 20-minute mark for this lecture. I hope everyone is doing well and doing your proper social distancing and staying away from the zombie virus. And I will see you in another video here very shortly. Everyone take care.